Hello, everyone. My name is Scott Marcus. I'm a senior fellow at the economics think tank Bruegel. I have the honor of moderating this session. Now, 100 years ago, the great American retailer, John Wanamaker, liked to say that half of his advertising dollars went wasted. The trouble was, he didn't know which half. Targeting advertisements has been with us for a long time. Even 100 years ago, advertisers chose which advertisements, which media they used, which newspaper, which magazine in order to target specific demographics. With the shift to digital, the granularity of that targeting is far greater. And this raises many new issues. It raises issues of personalization, of privacy, transparency, ad prominence. All of these are relevant. And with that shift, we have a range of new legislation coming into play, proposals for a Digital Markets Act, a Digital Services Act, a Data Governance Act. So many things going on that have to interplay with existing legislation like the General Data Protection Regulation, the GDPR. We have a great set of panelists, so I won't spend more time talking now. You need to hear from them. I've asked Irene Roche Laguna, who's the Deputy Head of Unit for Digital Services and Platforms at DG Connect, to make introductory remarks, specifically telling us about some of the new legislation that's coming down and how it seeks to address precisely these issues. And with that, over to you, Irene.
Thank you very much. Good afternoon, everyone. Just a few words of framing the DSA package. So both the Digital Services Act and the Digital Markets Act is a very comprehensive legislative framework. So we are spending the whole day going into the details today. And thank you very much for organizing this event. From my perspective, it is it's both exciting and overwhelming task to go through these legislative procedures. We need to deliver for citizens and for European businesses. And in this sense, the Commission has played its part. And I think I am very confident that we have done our work right, as the proposals have received quite a broad, convergent and positive views from stakeholders, not the least because we have followed very closely all the debates, also in the European Parliament, as Timo will show, as regards the preparatory works towards the own initiative reports. So very few words in general on the DSA. The instrument that we propose is horizontal. It covers liability and responsibility, creating two different parallel channels. And it's asymmetric. It tackles the problem there where the problem arises, and it's more prominent. What does it mean, this, in particular as regards advertising? So for advertising, it's important to stress that the DSA and the DMA are not regulations on advertising. It's broader than that. It deals with advertising to the extent that it represents a risk and needs for diligent intervention by online intermediaries or by gatekeepers, in particular online platforms. It's also important to note that the DSA, for instance, applies only to online intermediaries and not to the whole spectrum in the ad tech. So it's horizontal. It applies to all types of advertising, commercial and non-commercial. We can discuss about that. The liability and the responsibility are two different channels also for advertising, and that breaks some ill-defined arguments that popped up in the in the past, saying that those platforms that know exactly our deepest secrets and our best desires as regards which products we want to buy, they know everything, hence they should be liable. We think that these are two separate matters that need to be treated separately. And it is asymmetric. We impose different layers of obligations also as regards advertising. So there is a first layer of transparency for online platforms, which is based on the principles already established under the e-commerce directive, but also covering non-commercial advertising, and also transparency on main parameters on profiling. But then there is a deeper layer for very large online platforms, where we request to be especially transparent and have ad repositories with further information on profiling of users, to conduct risk assessments and prepare and propose mitigation measures that also can have a link to advertising in particular, and give access to data both for regulators and for researchers, and breaking in this way information asymmetries that we are contemplating today in the world of advertising. But it's not only about the Digital Services Act. Also under the Digital Markets Act, we propose a certain a series of rules that will have an impact on online advertising. We increase the accountability in the value chain by providing obligations of information to advertisers and to publishers by gatekeepers. Also framing the data use and the sharing of this data, and imposing an obligation on auditing profiling for the users. So all these measures together, we are very confident that will shed light on the advertising ecosystem and will help us tackle the problems there where they arise. Thank you.
Thank you very much, Irene, for this very clear introduction to the topic. And with that, I'd like to hand over to Timo Völken. Timo is a member of the European Parliament. He's active in the jury committee. So he's going to be seeing these measures, or already is. And with that, over to you, Mr. Völken.
Yeah, thank you very much, first of all, for the invitation and for the introduction. So I will just try to explain shortly what we in the jury committee decided when we discussed the matter of personalized advertisements intensively before we finally concluded our report with our recommendations to the Commission for the Digital Services Act with regards to targeted advertisements. And maybe to start with, it's maybe not surprising that I'm not completely happy with what the Commission proposed in the DSA with regards to targeted advertisements, because for me, it's more or less only transparency, increased transparency. So users should be enabled to see why they are shown specific ads, but I think this is not enough, and the Parliament was quite clear on that. So in our report, we asked the Commission to table a Digital Services Act that sets clear boundaries and introduce transparency rules as regards the terms for accumulation of data for the purpose of offering targeted advertisements, as well as regards the functioning and accountability of such targeted ads, especially when data is tracked on third-party websites. So we wanted to see that measures are established that help consumers to protect themselves for digital nudging, for example, for preferential treatment. So in the end, we called as the Parliament, the Commission, to assess options to regulate targeted advertising strictly, including a total phase out of digital off-targeted ads. So this is, I think, the strongest call a parliament ever made with regards to advertisements, and I'm pretty proud that we made this happen, to be honest. Of course, this was tried to delete from the report, but in the end, a majority of members decided that we finally need to address this issue. And of course, I'm aware, and I can imagine that the Commission will argue that the question of cookies is dealt by the e-privacy regulation, and the DSA shouldn't mess up with the e-privacy rules. But to be honest, since we are waiting since 5 years for e-privacy rules, and what the Council put on the table as their general approach isn't convincing at all, and it wouldn't solve the problem of targeted ads. So I think it's important that the Parliament backed my request here. So maybe to just look in the future, I think yesterday or 2 days ago, Google announced its plans to get rid of tracking via third-party cookies until next year. And I saw some enthusiastic newspaper articles about it, but I'm not as enthusiastic because tracking will not disappear by banning third-party cookies. For example, whenever you logged into a service on a platform, they will follow what you're doing on the internet and create a profile. So when you are logged into Amazon services, Amazon will, of course, track your behavior. If you're logged into Google services, they will track you. So for me, it's a step in the right direction. And from what I can see, Google proposed to the standard setting body W3C that users shouldn't be targeted individually anymore in the future, but users are put in comparable profile blocks. I think they call it flocks, so that advertisers can only address these flocks and comparable profiles and not an individual profile. So, of course, the ad industry is not lazy too. The proposal of advertising ID is on the table, and the claimed benefit is that that it creates pseudonymity. So, but for me, this isn't enough. If you gather enough data sets, you can reconstruct the pseudonymity, and you, in the end, still know which user did what on a computer. Browser companies are suggesting solutions too. Firefox, for example, introduced a stealth mode where you can opt out of third-party tracking. But what happens if, for example, tracking software is covered, is covered in a first-party cookie? So this happens. So this is not protection at all. So in the end, I see still many problems, and this is why some members of the European Parliament are forming now the Tracking Free Ads Coalition, and we advocate for legislation that contributes to ending the collection and use of personal data for the purpose of showing personalized digital advertising. And maybe let me end. I'm not completely foolish or silly. I know this is a very difficult task, and I know that we need to have EU-wide solutions for that. And it's not only the companies who use the tracking services, it's also the advertisers who are really responsible what happens with their budget they allow or they spend for advertisements. So if they would say, we do not spend our money for personalized ads, then there wouldn't be so many companies using targeted ads. And of course, we need to have a regulatory framework which protects the interest of industry in earning money, example, quality journalism. But we also need finally rules to protect the fundamental rights of users. And this means also their right of privacy and not being tracked when they are using the internet. So maybe it's the first statement.
Well, thank you very much, Mr. Wilken, for an interesting and I have to say quite informative and also somewhat provocative opening statement. I think it would be useful actually to have Townsend Feehan speak next. Townsend is the CEO of the Interactive Advertising Bureau, and so you folks are involved a lot with technical standards for the advertising sector for some of the largest entities in North America and Europe. I'm pretty sure you'll have some responses you want to make.
Hi, can you hear me? So very nice to be part of today's event, and interesting to hear both of the previous speakers. And indeed, it does prompt some reflections from my side that I'll share, and then look forward to the ensuing conversation. So on the transparency item, sort of the adduced topic of the panel, my own association is particularly invested in transparency as a concept. So I should say briefly at the beginning, we represent between 4,000 and 5,000 companies across Europe, 25 national federations, and people across the advertising chain, from advertisers to agencies to ad tech companies to publishers and providers of other online services and content. And when the GDPR came in 2016, we began working on a legal compliance standard, transparency and consent framework, to ensure harmonized information disclosures to users and enable websites to establish a GDPR legal basis or e-privacy consent as necessary or appropriate. And on behalf of partners delivering advertising on their sites. And that standard is now deployed on over 500,000 websites and across Europe. And we'd love to have a Forum Europe event someday to present it. With respect to what the net addition of the DSA proposal that we've seen from the Commission would really add. It seems important to start from the position that there's quite a lot of transparency already provided in the existing law. With respect to tracking, of course, people don't have to be tracked. They can they don't need to agree to tracking. But the current law requires the provision of a lot of information already about who is behind an advertisement. So the identity and contact details of the data controller or controllers, purposes of the processing, legal basis for the processing, anyone else whom the data might be shared with, information about data transfers or how long the data might be held and for what reason. And then the existence of all the different user rights that are foreseen in the European law. So that's the right to access data held by any company about the user, right to rectification or erasure, right to restrict or block data processing completely, object to it, right to withhold consent, and the right to data portability. And then, of course, the law already requires information disclosures to users about profiling, whether that's profiling that may have legal or comparable consequences, or profiling that wouldn't have such serious consequences. So it's possible that the DSA mandating some more information disclosures about the logic, for example, the logic of an algorithmic logic, would add something, but it seems reasonably marginal. The most important challenge, in our view, and the priority ought probably to be enforcing the existing law, but no objection as such to the transparency, additional transparency disclosures that are foreseen with respect to advertising in the DSA. On the topic of banning targeted advertising, so that is, I say, making it completely impossible. As I said, people can already just decide they don't want to be tracked. The law gives them that right already. So what we're talking about actually is a law that would take away from people the possibility to decide which services and online content and services they'd like to pay for with money, and which online content and services they'd like to pay for with attention. Most of us don't pay for everything we consult online. And most of us would probably agree that the possibility to make a choice, depending on your economic circumstances, is also a pretty important consumer and citizen right. Mr. Wilken made the point that, well, in a different way. So we can purport to ban targeted advertising, but as he said, there are probably limitations to the degree to which we can achieve that. And we can't do anything about the fact that there are always inherently going to be large first parties. And that doesn't just mean the platforms, but large first parties with attractive content that have a range of services and a scale of user base that will enable them to be more attractive places for advertisers to put their spend. And targeting with all the constraints and protections built into the law acts as a kind of democratizer or equalizer, allowing small sites, generalist media that are responsible for local, investigative reporting, allows them a realistic possibility of pitching for that advertiser spend in a way that they wouldn't have if one simply forbade targeting completely. Arguably, as I said at the beginning, the better option is effective enforcement. So I think it's obvious that there have been there's been a real challenge in the DPAs and the European Data Protection Board together enforcing compliance with the GDPR. My industry would be in a better position if there had been more visible enforcement of the law, because the absence of more effective enforcement allows the perpetuation of a narrative that was sort of, well, they're all bad, as long as you don't draw out the bad actors and highlight the fact that there are some good actors. The whole industry suffers. And the last point I wanted to make was that I'm not sure there's any obvious reason why specifically getting rid of targeted advertising or getting rid of it on all but the largest first parties would actually reduce the amount of online disinformation and hate speech. So I'm not sure there's a connection between targeted advertising and online disinformation and hate speech. A lot of the online disinformation and hate speech is content and not advertising. But I guess we would agree that where online disinformation, hate speech is advertising, then indeed it would be, it's probably correct that introducing more constraints on the use of data-driven voter segmentation and micro-targeting of political advertising would be a positive thing, an important thing that's not foreseen in any law currently. So those were the little opening observations I wanted to make. Thank you.
Well, thank you, Townsend, for some pretty interesting opening observations. I think it would be most interesting to give David Martin from BEUC a chance to jump in now. I'm sure that he'll also have some observations. This is turning into a pretty lively panel, which I appreciate. David, over to you.
Thank you very much. To be honest, after that last intervention, I don't know where to start anymore. So I will start by saying that we fully agree with what Mr. Wilken said about transparency. Transparency is not enough. Transparency is still a problem, let's say, but transparency is not the solution to the problem that we have, broadly speaking, with this type with advertising and behavioral tracking, etc., etc. We cannot put the onus on the users even more. Besides, everything is rigged, let's say, or designed in a way for them to accept being tracked and being profiled, which takes me to the second point I wanted to make quickly about what Mrs. Feehan said about that it's, if you don't want to be tracked, it's very easy. You just simply say no. It's not as easy as that, unfortunately. There's a lot of different elements that are put in place for the consumer to simply accept and move on. And even if you try to say no, it's not possible because the tools do not work, or because the websites or the apps do not always respect your choices, for example. So it's not as simple as that. And about paying with money versus paying with attention, the problem right now is like the second option is not paying with attention. It's paying with attention plus paying with your privacy and fundamental rights, which is a much, much higher price, I would say. Because if it was just about paying with attention, we have no issue with that. Advertising and advertising funded business models have been around for centuries. So the problem really relates to one specific type of pervasive advertising, which is having a negative impact, not only from a privacy and personal data perspective, but the problems it creates go far beyond that. They are related to manipulation, to discrimination, even wider societal problems and negative impacts on our democracy, as we can see from the Cambridge Analytica scandals and what happened in the Capitol recently, earlier this year in the United States. So I think that there are a lot of different issues that have, let's say, surveillance advertising, although the industry has nicer words to portray this. They call it interest-based or data-driven advertising, but let's call it surveillance, because at the end of the day, it's based on tracking and profiling, on spying on people to exploit their vulnerabilities, let's say. So the business model based on this type of advertising are the root of a lot of different problems. So this is something that BEOC and our members, we have been looking into this for quite some time. And it normally comes in the context of privacy and data protection. So we are happy and we're glad to see that this is coming up in a wider policy discussion now in the context of the DSA and the DMA and other initiatives. These ad tech business models, as I said, we believe that they're having a very negative effects on consumers individually and society as a whole. And we have several reports and actions that have been carried out by our members in the recent times that illustrate these issues. So I would start, for example, mentioning that last year in January, our Norwegian member, the Norwegian Consumer Council, published a report called Out of Control that looked precisely at this hidden side of the data economy and what goes on with when you're using certain apps on your mobile phone, to whom they're sending data, what happens with that data, what are the harms that can derive from these uses of data that are made. And it really pointed to a systemic breach of fundamental rights that is happening on the data ecosystem because of this advertising that is basically pervasive and widespread, present everywhere. And on the basis of that, we called together with our members for an investigation into these practices. And the Norwegian Consumer Council also filed a series of complaints on the basis of GDPR. And in January, the Norwegian Data Protection Authority already came up with the first decision, of course preliminary, because this is still being discussed. With Grindr, they basically said that Grindr is breaching the GDPR and pointed at different issues related to how online advertising, this specific behavioral advertising, is working. And now a couple of weeks ago, mid-February, we released a report and an action against TikTok, and we found again same practices that were in the Grindr decision and in the Out of Control report, which are happening. So the issue is widespread. It's not only about cookies. It's not only about cookies, but cookies are still a problem. I mean, they've been a problem for a long time, but they are still a problem. You just have to look at the cookie notices. I think that the amount of cookie notices there that respect basic GDPR requirements or basic e-privacy requirements is not that high. And this without thinking what's behind them. Because once you click on consent, provided that everything is presented to you in the right way, there's still even a problem with what happens after that, because there's no way that how the data is handled and what the data goes and how is it used, that doesn't respect basic GDPR requirements either. And on cookies, our member Consumentenbond just yesterday published a survey. They looked at 100 websites, popular websites in the Netherlands. Over half of them did not respect the rules. So some were placing cookies before you asking for permission. Some were placing cookies even if you told them not to place them. The conclusion of all this paints a fairly grim picture about the respect of fundamental rights and existing legislation. And I have to say also that it's not only about this type of pervasive advertising. We have issues in the digital economy with more traditional, let's say, concepts and rules, such as the fact that advertising needs to be clearly identifiable. On our TikTok report, you can see a lot of hidden advertising going on the platform, new forms of using users and consumers to actually be part of the advertising themselves. So the problems are widespread related to marketing, online and digital marketing. But let's come back to the issue about the systemic breaches. So is this just a problem of enforcement? And I would say yes, but not only. So we need to improve enforcement of the GDPR. Yes. We need to improve enforcement of the e-privacy regulation. Yes. We need to adopt a new e-privacy regulation. Yes. Unfair commercial practices. I mean, there's a lot of different rules that come into play here, but this is not the only problem. So next question, what else needs to happen? What else needs to be done? Transparency and user control. Is this the solution? Well, this is necessary, but again, no, it's not the only thing that is necessary. I think that there's a whole fundamental question we need to ask ourselves here about what kind of digital economy and what kind of digital society we want. What do we think is fair? What do we think respects our values or not? Do I want TikTok to simply tell kids what it's doing with their data and how it sells them stuff and how it targets them with advertising? Or do I want TikTok to simply stop profiling and tracking kids for commercial purposes? I think the answer goes more into this yes to the second question. And so from our perspective, as I said, it's very clear that we need to go beyond transparency. We need stricter rules. We need clearer and additional red lines. And the DSA and the DMA are one of the places where we can start doing that. And they already have some good proposals, but we need to build on them, and more will be necessary in the future to address all these problems that I mentioned. I'm just going to leave it there because I think I'm over my time probably. Thank you.
Thank you, David. That was quite fascinating. So that's quite a call to arms. Okay, well, I'd like to give the floor next to Professor Sophie Staller-Bourdillon. She teaches at the University of Southampton. She's a professor in information technology and data governance. So, Sophie, you're an expert, and you have the advantage here of not personally having a dog in the fight, so to speak. What do you think about all this? We've heard some pretty interesting views.
Well, thank you very much for giving me the opportunity to participate to the panel. It's a real great pleasure to be able to be with you this afternoon. A lot has already been said, but I'll try to add a little bit to the debate, and I'll start actually with the obvious, and I think it needs to be emphasized. I think it's good to see that significant resources have been allocated to that space, and that the EU is leading the thinking, just like it has and continues to be a lead actor in the field of privacy and data protection. And what it shows is that the European Union is working up to the threat of opaque private regulation and the absence of proper oversight, and that's good news. And once again, the legislative process is, to some extent, is only starting, so there is room for improvement. And the European Parliament will have a key role to play here. The overarching goal of the DSA is to support a safe, trustworthy, and transparent online environment. While the goal is obviously legitimate, it is also important to get the methods right. And so what should we think about the methods? Again, Timo has said it, unsurprisingly, the regulatory task is here, fraught with difficulties. One key reason is the fundamental ambivalence of online platforms. So they tend to generate two opposing feelings, love and hate. And ambivalence is intimately related to the business model platforms adopt and the technology they deploy. And so online platforms are ambivalent, and as such, they don't neatly fit within traditional legal categories, such as publisher, editor, distributor, and even content provider. This is acknowledged by the European Commission, which states that platforms facilitate public debate, economic transaction, and the dissemination of information, opinions, and ideas. But at the same time, the European Commission notes that the digital transformation and use of these platforms has resulted in new risks and challenges, both for the individual and for society as a whole. So, for the first time now, the European Commission has tried to unpack societal risk here. And these go beyond the dissemination of unlawful or illegal content. These risks touch public health, civic discourse, and electoral processes. So that goes quite far. So how should the regulatory burden be calibrated then? So while regulating ambivalent social technical practices, you want to make sure that the regulatory methods used is not ambivalent as well. So it's very important to have a very clear message that is aligned with the goal, okay, which would be, I think, to reduce as much as possible private regulation and reduce the size and thickness of walled gardens, and try to shoot for simplicity. So this is why I think the red line message that David was trying to give is quite attractive. And trying as well to err on the side of fundamental rights and freedoms. So what about the rules that relate to advertising then? The intention behind Article 24 and 30 is certainly good, and it makes sense also to put more pressure on the very large online platform. Article 24 aims to set a common denominator and provides for online transparency, online advertising transparency. So my main observation here would be related to the following. When you try to complement an existing framework that is already very comprehensive, such as the EU Data Protection Framework, you want to make sure that the new additions are not destructive or distracting. With Article 24, we try to make sure that recipients of services are in a position to understand that the information displayed is an advertisement, who is behind the advertisement, and why is it that it's there. However, we need to make sure that such a transparency obligation is not distracting from the fact that programmatic advertising in many cases requires consent, and getting informed consent within the meaning of GDPR is a demanding requirement and is in many cases not obtained. That the requirement of purpose limitation also needs to be complied with, and in some instances it is not, as well as the principle of security that we find in GDPR. So what is therefore needed, and we've spoke about that, is also proper enforcement of existing rules, such as GDPR. This is obviously acknowledged by the European Commission, in particular in the European Democracy Action Plan. But as a rule of thumb, transparency is worth pursuing when it leads to more accountability or at a minimum more intervenability. And so by accountability, I mean that the actor should be responsible for the action, should be asked to justify action, demonstrate compliance, and be in a position to correct action and remedy harm when needed. And intervenability is to give the possibility to individuals to ask for corrections and remedy. In other words, the information that is being given is not given purely for the sake of transparency, but it should be actionable. So there is probably here room for improvement and clarification as to what types of actions could follow. Finally, going back to the disruptive potential of the data protection framework, unpacking this potential is key for another reason. So it's to make sure that the data protection framework is not used as a pretext to strengthen the position of very large online platforms, which seems to be happening, as in particular illustrated by the research produced for the Observatory on the Online Platform Economy in the field of advertising. In fact, going further even, the research produced for the observatory also shows that publishers and advertisers have concerns, in particular in relation to interoperability and the flow of data. And the protection is used as a pretext to consolidate walled gardens. So to conclude, we are actually in quite a good place to be. There seems to be consensus that the model is actually broken, and therefore it's very tempting, therefore, to try to do everything to switch the model and take a new direction, which would be more protective for fundamental rights and preserve and increase individual agency. Prabhat has said this morning that the proposal was 80%, 89% there. So therefore, he acknowledged that there is room for improvement. The work has been done by the European Parliament in this space is very interesting, and I hope he will trigger more discussion. Thank you. I think that's it.
Okay, thank you, Sophie. One question which I'll pose first to you and then open up to the other panelists. You talked about the Democracy Action Plan. Obviously, political speech and political advertising were implicit in a number of things that you said. Do you see those as being distinct, or do you think that from the kind of matters that are covered by DSA and DMA, or do you think they can all be covered in one place?
They are not covered all in one place, I think, and the intention is to have an additional proposal to come up with specific rules for that matter. I think it makes sense to distinguish here because the context is different and the interest at stake as well. So,
good. Anyone disagree with that? I don't hear any disagreement. Okay, why don't we take a question or two from the audience then? Let's see, one of the questions that we have is from Robin de Voters, communication.
Sorry, Scott, would it be okay if I just came back on something that David said?
Sure.
I'm not,
Sure, off you go.
Sorry if I've spoken out of turn. I just wanted to make sure the record was clear that, for example, in the Grindr case, I mean, if there was processing of sensitive category data without explicit consent, then that's obviously illegal. And if sites are dropping cookies without consent, that's illegal. And the websites that David evoked that have UIs that don't comply with the requirements of the GDPR, that's illegal. But those are enforcement issues. They are not. They're enforcement issues, which is part of the point that I was trying to make at the beginning. Sorry to have jumped in.
That's okay. I think that Irene also asked to jump in, so I think I'm quite okay with this. I think it's good to have a little debate. Irene, what did you want to jump on now?
Yes, I wanted to reply to some of the other panelists before we enter into particular questions, because this issue of online advertising is very complex, and we are covering different topics all together and building a sort of a cake layer after layer, and it's important to separate the different tracks. So one track is that of access to data. And to what extent the data and the profiling takes place in line with the rules under the GDPR. And there is where the DSA should not be an instrument in order to enforce the GDPR, or even worse, to modify the GDPR. So I think we are all, there is a level of consensus on what the GDPR has done for users, and the obligations that it contains for data controllers. So it is about enforcement of the GDPR. So the starting point of the DSA is that the data that we are talking about, that is used and collected in order to profile users for the purposes of serving ads, is collected on a legal way. And there is the need for consent in certain situations, and the right to object against the data collected for legitimate interest. So the rules are there. But then it's not that we are saying transparency is everything, and the panelists have said, well, transparency is not enough. I think we all agree with that. It's not only about transparency. And if you look into the where we tackle advertising under the DSA, indeed the titles of the provisions hint that it's only about transparency, but this is if you allow me the joke, it's a sort of misleading advertising, because it's also about risk assessment and risk management, in particular for very large online platforms, which are the ones that we care about. Let's be honest, we are talking about the big platforms that are the public spaces, as we say, and are concentrating all the users around Europe. So for these platforms, we ask them to identify the risks posed by the way they organize their systems on their platform. So they need to avoid first that illegal content is disseminated, and ads are and advertising is a way of fueling also traffic into content which is illegal, but also content which is not illegal but it's harmful, is extremist, and we are always talking about the rabbit holes and the clickbait mechanisms in order to collect advertising revenues. So they also have to check the risk that it poses for certain fundamental rights. And here we name in particular the respect to private and family life and the prohibition of discrimination. So content, also ads that are illegal or that are discriminatory, should be avoided under this risk management system. So on the basis of that, very large online platforms should put in place measures to mitigate those risks. And then obviously the third layer of questions that we are discussing is the particular content of the ads. So the ad can be perfectly legal, but be served in an illegal manner because the data have been collected illegally. And when the content of the ad is illegal, then we deal with the rules under the DSA, following the rules on due diligence and also the rules on liability. And this leads me to the last point that I wanted to mention as regards the political ads. Because as I said at the beginning, the Digital Services Act is horizontal. It covers all types of content and also all types of ads. So we went beyond the traditional limitation to commercial advertising. And now we are tackling also non-commercial advertising. But the European Democracy Action Plan is also foreseeing a specific intervention for political ads, because they might be illegal, they might not be illegal. It is a very sensitive zone where it would have a strong impact on freedom of expression and information. And in this topic, we are opening a public consultation, and we will deal with that particular issue separately.
Okay, so just a second. Okay, I'm back. Thank you. So that was helpful. So a question now. So I think what you were referring to here was the framework for very large online platforms that starts at Articles 26, 27, the part that includes mitigation of identification of risks, mitigation of risks, and periodic audits. Clearly the risks here include content that's harmful, not merely content that's illegal. And the intent is to pick that up through the language about fundamental rights. Do you think that most of the harmful content will in fact be picked up through this mechanism? Do you have a feel for that yet?
Define picked up. What we do not want is to
Fair point.
have online, harmful content be treated as illegal content. We think that the content which is awful but lawful should not be taken down, for instance. But what we need to break are the wrong incentives for the dissemination and the amplification of that content in the first place. And second, manipulation. And this is specifically mentioned and covered under a specific risk, the possibility to have these very large online platforms manipulated in order to have a negative impact, a negative effect on public health or protection of minors, civic discourse, which is something that we have seen, for instance, in the context of national political elections, for instance.
Okay, thank you. I know Mr. Wilken wanted to jump in, and actually, I also wanted to mention there were actually several initiative reports, 3, I think, from the Parliament to the Commission asking for the Digital Services Act. This notion of making a distinction between illegal versus merely harmful was really very much visible in the input from the Parliament to the Commission. So I guess with that also as an introductory thought, over to you, Mr. Wilken. I know you wanted to intervene now.
Yeah, thank you very much. And indeed, I just wanted to underline that indeed all 3 reports from the Parliament have this distinction between clearly illegal content and harmful but legal content. And I'm very happy that the Commission took this on board. Of course, the distinction could be clearer. For example, I'm looking at the Article 6 of the DSA, so where they incentivize voluntary filter mechanisms. So this is something I wouldn't support, but the distinction is good. And this is very interesting that we are now speaking about this, because here is a difference between what Ms. Fien said and what now Ms. Laguna said and what I am trying to advocate for. There is a connection between advertisements, collecting personal data, creating profiles, and showing and presenting users of platforms specific type of content. Because the profiles platforms collect of the users are also used to present them content to incentivize them to stay longer on the platform. And this is the most important point. We really need to zoom out a little bit and look at the bigger picture. So take, for example, the discussion in Australia or the fights during the copyright directive. It's about the money. It's about the question, should platforms be the only ones who profit? And of course, they shouldn't. But can we regulate it by sectoral laws, or should we take a bigger approach, a more general approach, and asking what's the business model of these platforms? And the business model is selling advertisements. And they are earning a lot of money from the advertisers. And users are not paying. Good. Of course, you could say they are paying with the data, but they are not paying for the service. So they are not the customer. They are the object. And this is, I think, what we need to make clear. And that's why I'm advocating so strongly to take a general approach, to take approach at looking where comes the money from, and to start regulating this question. And the biggest problem really is that there is the business model of targeted advertisements, collecting data, sorting people, suggesting them content to stay longer on platforms. And this fuels online debates. This incentivizes content which is attention seeking, and not only the boring factual content, right? So this is why I'm asking to take a general approach. And two more additions. Yes, we have rules. We have rules for collecting data. We have rules for using cookies, but the rule book isn't completely written yet. So we are still missing the privacy regulation, which is a big pity. And as I said in the beginning, I'm not convinced that we will end up with a very strong piece of legislation. This is also the member states are to be blamed for. I think the Parliament's position is quite user-centric. But in this gray area, websites and online service providers, platforms, they try to nudge the users into accepting, for example, the tracking, into accepting cookies. Like David said in the beginning, I don't know if you understand the cookie banners which pop up. And they changed after a ruling. Now you can also opt in and opt out from the legitimate interest, for example, and it's not very user friendly, and it's an illusion that users are willingly decide to give away their data. They just click accept because they can't spend time, minutes on every website to opt out of all tracking services. And in the end, and I'm finished with that, after opting out, they click in the end the wrong button because it's green and big, right? So, and in the end, you accept all cookies again. So I know that these dark patterns are very difficult. So yes, we have the rules, but they are not strong enough and they are not user-friendly enough yet.
Thank you very much, Mr. Wilken, for this very thoughtful contribution. I know the economist John Maynard Keynes liked to talk about the luxury of not bothering. And as you say, the green button makes it easy. I think this is also very much in line with David Martin's comment about the deck being stacked essentially against the user, that it's a little too easy to say yes. But David, I think you wanted to jump in with something at this point.
Yes, I just wanted to quickly react on a couple of comments. There's first of all, I would like to mention that, as I said, we think that there's a lot of good things already that are coming as part of the DSA and the DMA. But the message here is we need to build on those. We need to go further. For example, we care about very large platforms, but we do not only care about very large platforms. I think there are some basic rules for consumer protection that should be there regardless of the size of the platform. Second point about the issues with enforcement and the fact that basically a lot of what's happening is already illegal. I would come back to, we have a problem with that for sure. But as Mr. Wilken just said, the issue here is that we need, again, stricter rules. We need something more. And this is what I was talking about, that we need to ask ourselves certain fundamental questions about which way we want to go. So just to try to put a comparison, let's say, with the Dieselgate issues, you had a car manufacturer that was gaming the rules in terms of how you measure emissions and design the engines, right? So these are the guys that are breaching the GDPR now. But then we took a further decision, is that we didn't want diesel anymore. So we're looking into how we want to phase out diesel. So that's a question that we need to ask ourselves now. How do we want to do this, and how do we do it?
So where do we fundamentally want to go? Well, Irene, unless I greatly miss my guess, I suspect that you would want to jump in and say, but the DSA already contains different levels of obligations for different kinds of intermediaries. Not so, Irene?
Yes, and not only the DSA. I think those who know me know that I am a huge fan of the e-commerce directive. I have a tattoo here saying e-commerce directive. No, I'm joking. But it contains already, since the year 2000, it contains rules of transparency on commercial communication, so advertising. So already all information society services, not only intermediaries, all online services have to be clear and display clearly what is an ad and who is behind the ad. And this has been there. If we don't know yet what is an ad and who is behind the ad, it's a problem of enforcement. And this is for member states to blame, after all. So under the DSA, as you say correctly, it's not only about very large online platforms. There are also transparency rules on advertising for all online platforms. So obviously not all, because we exclude micro and small platforms for reasons of proportionality. But this obligation of transparency builds again on the existing rules, on the e-commerce directive and consumer protection rules that are there for years. And they extend these obligations not only to commercial communications, as I said at the beginning, but also to non-commercial communications. So it's not only about very large online platforms, but let's be honest, this is where the problem, where the money is. So it's not only advertising as a problem and data collection as a problem, as big as the problem might be, but is what this advertising money is fueling to. It's illegal content, it's harmful content, that it is exacerbated and disseminated and amplified because of the possibilities of making money out of it.
Well, I'm an economist. I'm a fan of following the money. Okay, up to now, we actually haven't heard from the audience. I'd like to get at least one of their questions in, and we've got about 10 minutes left in the panel. And by the way, thank you all for a very lively debate. So we have a question from Lindsay Starnzer. Could the speakers comment on the convergences and differences they expect to see emerging between what the EU is doing with the DSA in terms of political advertising and what the US has been considering around a revamp of Section 230? For those who don't know, Section 230 of the Communications Act of 1934 is amended. I know this, I'm a former US Fed, deals with essentially an exemption from liability for intermediaries. There's an argument in the US, much as in Europe, that perhaps that exemption is too broad. So does anybody have thoughts about this? Yes, over to you, Irene.
Yes, thank you. I don't want to monopolize this, but we are also very much looking into what's happening in the United States and the discussions around the Section 230. And indeed, I think they refer to a draft legislation in order to remove that immunity from, in particular, from social media companies when they knowingly publish demonstrably false political ads, which is a probatio diabolica in a way. In particular, because ads are shown without any control by the platform. They offer the space, and in the case of the big ones, they own all the parts of the ad ecosystem, but not all of them. So that, to me, would not be translatable into the European rules, because we have the provision of general monitoring obligation. So otherwise, they would need to go one by one to the political ads that are shown to check and to have some fact-finding exercise in order to check whether it is demonstrably false political ads, which is also a very difficult test.
Yes, it's challenging. Trying to do demonstrably false without limiting political freedom of expression is, I think, a big challenge. While we're on the U.S. comparison, there's also very much a discussion about a possible revamp of U.S. competition law, antitrust law, embracing some of the same principles that have certainly been in the discussion for the Digital Markets Act. Should there be restrictions on vertical integration and so on? Does anyone have any thoughts on that discussion? Some of you may have seen there was actually a House Majority report during the previous administration, and there may very well be, or perhaps already have been, legislative proposals based on that. Any thoughts? Okay, I guess not, but I think we have a transatlantic dimension to the discussion. Let's see, one other question that we have in the chat stream comes from Robin de Wouters, communication coordinator of EDAA. I think this will be of special interest to Ms. Feehan. It's what can industry self-regulation do to tackle transparency in digital advertising? Any thoughts on existing mechanisms? It mentions a couple such as ad choices or your online choices. Is there more that can be done with voluntary or self-regulatory, co-regulatory mechanisms?
I
think I see a head shaking no. David,
maybe I would just say, like, sort of generic, neutral way, that the DSA and DMA, unless I'm mistaken, both seem to foresee a role for codes of conduct, but those codes of conduct would obviously come with quite strict oversight and enforcement, a role for the Commission and authorities in enforcement.
Yeah, it actually seemed to me, by the way, the section I was talking about before, the Article 2627, the risk mitigation, I also view as being basically co-regulatory. It has the companies identifying the measures that they would take to mitigate, but a clear enforcement capability for the for public authorities, for the Commission. David, I know you wanted to jump. I'm sorry. Yes.
Sorry, that may be a better co-regulation, may be a better term, indeed.
Yes, David, I think you wanted to jump in.
Yes, very quickly. I mean, from our experience, self-regulation doesn't work. So we don't have a lot of hope on that one, to be honest.
I'm not surprised. Yeah, the limitations are clear. Timo, I thought I saw you nodding. Did you want to jump in?
Yes, very quickly, because I want to also say a few more positive words, especially the Commission's approach when it comes to political advertisements. I think it's moving in the right direction, and here we see what's possible. So if the Commission suggests not to allow targeted political advertisements, I don't understand why it shouldn't be possible for other advertisements too. So the approach is on the table. I can support it. And I just would have wished for a more stronger DSA proposal in regards to general advertisements. So I don't think that, more transparency is the solution. We are past that. So now we need legislation.
Okay, well, thank you very much for that. Tell you what, we've got about 5 minutes left in our scheduled slot. I'd like to give people an opportunity to make closing remarks, if any. And we've got about 1 minute each, if we care to take it. Irene, why don't we go in the same order that we made the introductory remarks? Irene, would you like to go first? Do you have a closing thought or two?
Perfect. Thank you very much. My closing remark would be just an invitation to everyone, so all the stakeholders, but in particular the Parliament and Member States, to now enter into the possible improvements, but please not only improvements, not worsening or not weaken our proposal, because we are actually quite proud of it, of both of them. So it is the moment now to work together, and we are also very, very optimistic about the ideas that we see around. So we will be happy to help in this legislative proceedings now, and also in particular having in mind that we have a researcher in the panel, to stress the need and the call for researchers to also play their part in the role of public oversight that we can have, because it's not only about shedding light, it's also about understanding what we see under that light, and this is going to be also a challenge in terms of enforcement.
Thank you for that. You've also got a researcher as a moderator. With that, I'd like to give the floor to Mr. Wilken.
Yes, thank you very much. I don't know if you can still hear me and see me, but I already see the end screen. But now we are back. Okay, good. Yes, first of all, thank you very much for the possibility of this exchange. Very much appreciated. And I think this only is the starting point of very intensive years of debating, maybe a little bit of fighting, but in the end, aiming to have indeed a DSA and DMA package, which could truly be considered as the digital constitution of Europe. I think it can't be underappreciated what the Commission proposed. So it's a good starting point, with all critics coming from the Parliament, from the Member States. I think the Commission expected that, but it is a good proposal. It is a good starting point, and we will have our fun with that. Hopefully not longer than 2 years, but I think we will need 2 to 3 years to come to a final agreement. My understanding is that the council, the different working groups are still fighting which working groups should be responsible. In the Parliament, we have the same situation. So the committees are fighting quite heavily which committee should be the lead committee and which committee should be allowed to give an opinion. So thank you for this very interesting start, and I'm looking forward to meet you again.
Thank you, Mr. Wilken. Okay, so over to Townsend Fian. What do you think about what you've heard?
Well, I just one very small closing remark. I think again, sort of along the my leitmotif of let's look at what's already on the table. GDPR, in my view, and I think I would hope DG Just would say the same thing, provides for transparency plus control, plus a baseline of security, privacy by design, privacy by default. It's not just transparency. I hope that whatever is ultimately adopted in the DSA and DMA proposals does solve real problems and well match any new or supplementary provisions to the adduced objectives. And it's been quite good fun to be part of the panel, and I appreciate the invitation and looking forward to the next few months of discussion too.
Great. Well, thank you, Townsend. And now over to David Martin.
Thank you. It's been a pleasure to participate as well. I would just say to close that we still have a lot of work to do ahead of us. So enforcing GDPR, adopting e-privacy regulation, adopting DMA, DSA, I hope those take less than the e-privacy regulation at least. And but all this is fundamental to ensure that we have a fairer digital economy and a fairer digital society. And we look forward to contributing to that objective.
Well, thank you, David. And now over to Sophie, Professor Stahler-Bourdillon.
So, the research has been heard and will be, I'm sure, very happy to help. I'd like to broaden up the debate and include also within the package or alongside the package, there is also a very interesting act that is being put on the table by the Commission, which is the Data Governance Act, and which is also an important piece to try to diversify access to data as much as possible, which is very much needed in this space. And again here, as well as in the field of advertising, the key here is to try to understand what are the alternative models. And so beyond regulation, prototyping new practices and understanding their impacts is key. So more food for thought and I guess research as well.
Well, so thank you very much to all of you. Actually, by way of closing, first I'd like to start by commending the Commission. I think that all of these three DXA submission proposals, Digital Markets Act, Digital Services Act, and Data Governance Act, I think they all represent a very good basis for discussion. It will be a very busy discussion, as we've heard today on the panel, involving not only the trialogue, but also civil society and academics like Professor Stahler-Bourdillon and myself. So much work to be done. I'd like to really thank these super panelists. This has been a very thought-provoking and in some cases provocative discussion. I've enjoyed it very much. I've been greatly honored, and I'd like to thank the organizers. And with that, do the organizers have any closing remarks? This is, I believe, the last panel for the day. David, anything for you to say?
Hi there, Scott. Thank you very much for your kind word. I just thought I would jump on the stream to indeed say thank you to all of our speakers, our participants today, our partners and supporters. A special thanks as well to DG Connect and Irene, Pravat, Gerard's respective directorate and units. Thank you so much for the support. I very much appreciate this. It's been a very, very interesting, insightful day, full of we've received a lot of positive feedback, and there's lots of things to think about for next year's edition already. So thank you all so much for taking the time today to participate to this specific event. We hope to be able to gather in person next year. And until then, goodbye and take care.
Thank you.
Thank you.
Thank you. Goodbye.
Thank you. Bye.